but I thought I would mention it. In reviewing your website, I have a few questions. Maybe you can help me understand. According to your website, the PSC is responsible for enforcing minimum safety standards for the design, construction, and operation intrastate pipeline facilities used for the distribution and intrastate transportation of gas, liquefiable natural gas, or hazardous liquids, regardless of whether they are owned or operated by a public utility. Could you please explain to me in this particular situation what the facility is? Is it where the CO2 carbon is getting buried, or is it Summit? To me, they would be the utility, but I don't know what it means by the facility.
And as I indicated at the beginning, this is not the time or place where we take questions from public. Okay. It's just for you to provide public comments.
Okay. And the other thing that I'm concerned is if it is where the carbon CO2 is being buried, how will the reports get reported if it's in the earth? Excuse me. How much capacity is available now? And I'd like you to think about this. How much capacity is available now? And will the pump stations be used for CO2 in places that they will bring it up, or if they will use it for transport? I would much rather have them use it for transport and use it, because there's so many things they can do with carbon. I understand that if, excuse me, I'm sorry. 80% of the projects have attempted to commercialize or carbon capture and sequester technology have ended in failure. I don't understand why taxpayers' money, yours and mine, are used for technology that has such a poor track record. At this time, there is no proof that carbon will stay buried. I have heard it will adhere to the walls of the cavity and never be able to be brought up. Does it take, what did I do with it? Okay, does it take more pressure to have attempted to move carbon CO2 through I wanted you to see, or helps the people to see, an 18-inch pipe. That's what was first presented. And is it now it's up to 24 inches. Does it take more pressure to operate it, to push this carbon CO2 through at an 18 versus 24? And I guess I can't ask you how much difference it would be because I can't ask a question. But think about that. One of the concerns I have is the fault lines. We have had 13 earthquakes in North Dakota, according to the Geological Survey. 3 of them were in the eastern North Dakota. The rest were along the fault lines in western North Dakota. Earthquakes are caused by the sudden slip of a fault in the upper few hundred kilometers of the earth. So far, the earthquakes have been very minor, but we are burying lots of carbon CO2 in an area near the fault lines. St. Helena erupted because of too much carbon CO2 in one area, and it finally heated up. I have listed the latest earthquakes. Well, Oliver and Mercer County to Sheridan had an earthquake in the 1900s. Makati Fault is in Dunn County and Mercer counties. Goodrich had an earthquake on November 15th, 2008, with a magnitude of 2.6 and a depth of 11.2 miles. Renora had an earthquake on January 3rd, 2009, with a magnitude of 1.5 and a depth of 8.3 miles. Fort Berthold Southwest, which is in Dunn County, which is next door to Mercer County, had an earthquake on August 3rd, 2009, with a magnitude of 1.9 and a depth of 3.1 miles. Yellowstone and Missouri River, McKenzie County, had an earthquake on March 21st, 2010, with a magnitude of 2.5 and depth of 3.1 miles. Box Elder Creek had an earthquake on June 14th, 2010, with a magnitude of 1.4 and a depth of 3 miles. Southeast of Williston in Dunn County, which is next to Mercer County again, had an earthquake September 28th, 2012, with 3, I don't know why they do that, intensity of 3.1 and a depth of 0.04 miles. Now we're dumping carbon CO2 in an area near these fault lines. And what I did, you probably can't see it here. Let's see. Oliver, it goes right over part of the border. They're burying it right down here. I don't know how many miles that is, but that's how close it is to the fault line, one of the fault lines. There are several. Now, this isn't right here. This up here is Mercer County. They are burying it up to here. I would bet that it's only a couple of miles from the fault line, which extends all the way up here. Now, the other thing that bothered me was, and I'm assuming when you bury something, you don't put it in a storage area, you put it in an area, and the pressure is going to push it. I don't know which direction it will go, and neither does anybody else. It will follow along anything it can adhere to in the earth. I hear a lot of testimony on for, or not too much for, but mostly against. Now, when I see the carbon is buried near that fault line, and it's right in the area, that to me should be something that you guys would definitely think about for safety. According to the newest map I just picked up, it's not fault so far, right up here. Here's Mercer County. And guess what huge lake is right above that? So Lake Sakakawea. Now, has someone ever said if they go way down, I know that's what their plans are to do, if they're burying it for 10 years at 24-inch pipes, what kind of a pressure do you think that's going to be down there? If it wasn't quite so close to the, I had no idea it was how close it was to Lake Sakakawea. And that was a new area that was already taking a lot of land away from people so they could have the dam, which we need. We definitely need a dam. But I think that's, to me, a big consideration. The state's disposal wells inject salt water into the Inyan Kara, which absorbs the liquid like a sponge. I don't know where that is. So we are already dumping salt water into the earth. That is in North Dakota. I just don't know where. I'm assuming way out west. How much more can North Dakota absorb in the earth without us getting a backlash from Mother Earth? We are messing with an order that God created, and we have the best air in the USA. I know people who come back from Arizona and other states who have medical issues with breathing especially, and they'll say, thank God for North Dakota, because we have clean air. Our livestock and horses are at a premium. They're selling like hotcakes because they say there's something different about North Dakota's grass, CO2. The farmers are trying hard to produce more food every day. It will be a lot harder or maybe impossible if carbon and CO2 is constantly being buried. And even if they want a lot of corn for the ethanol plants, you have to understand that CO2 is a requirement and carbon is in that soil to produce the good crops. And since science already said carbon and CO2 should not be buried, that we need carbon and CO2 to live. I wonder how many children may not be born, or how many people will miss out on heart transplants, liver transplants, due to the lack of carbon for dry ice. Those are just a few of examples. Carbon is used for dry ice. You may not be on this PSC board in 10 years, but the decision you make regarding the burial of carbon and CO2 will be with us for a very long time. If you say yes to burying it for the safety and production of our food, and less things that will help us to live properly, that could be something to think about as well. I know you're getting pressure, and I know who you appointed you. And I feel you feel as well possibly that you have no choice. But I believe that you are very smart people and realize that how dangerous this pipeline is at being so 24 inches and having the pressure, but also for the length of time they're planning to run it. I believe that it will not meet the minimum required of safety. I know there's talk that they can have the meetings, but anybody who has a car or a vehicle, according to the one that I read on, stop just like that. They will not be able to get to the people who need the help. And if they're farmers, if they have what they say is going to be, they can buy the grant, or will the grant money that they are getting provide the people, all the farmers and ranchers who they have gotten things from, the land, the lease where it's run over. I don't know if they've ever figured out how many farmers there really are, or how many landowners, I should say.
Ms. Hagen-Mathern, can you wrap your comments up, please?
I will. And who will be responsible for the damage later on. I'm afraid with the destruction I feel could happen, and us being a dump state, I hear it all the time now, it doesn't really sit well with me. And when you think of them calling us a dump state, North Dakota, that's what they're calling us. And it breaks my heart. Yet I have to trust God, and we are trying to rely on Him to persuade you to make the right choice. Thank you.
All right, thank you. Mr. Gludd, any questions?
No, Your Honor.
Mr. Pelham?
No questions.
Mr. Broughton? Mr. Jordy?
No, thank you.
Commissioner Chrisman?
Just one, and you covered a lot of ground and appreciate that. But the parts of your testimony that had to do with the sequestration field, so we're here on this application for a pipeline. The sequestration field is determined and regulated by the Industrial Commission. Have you considered taking your testimony as far as faults out there in the Mercer and Oliver County areas and Lake Sakakawea and such to the Industrial Commission?
I did not. I don't know how to do, who was involved in that?
The governor and attorney general and.
Oh, well, the governor is the one appointed you guys, so I don't think.
Actually, no, ma'am.
Huh? You're not appointed by the governor?
Nope.
You're not? Oh, that's good to know. I did not know that. I'm learning something. I apologize. Okay, I'll think about that. But if they didn't have a pipeline, they couldn't bury it.
Right.
So,
I mean, that.
and safety to me is almost number one, plus the earthquakes, the fault lines being buried next to that. Yeah.
Those fault lines stuff might be something they might be interested in here. So I just thought I'd point that out.
Commissioner Haugenhofer.
Thank you for your testimony. I have no questions.
Thank you.
Mr. Dawson.
No questions, Your Honor.
All right, thank you. Do we have anybody else for public testimony?
Hi, everyone. I didn't want to get in front of anybody because I'm probably closer than most of the people here. So
I'll have you state your full name for the record and spell your last name.
my name is Jeffrey J. Magrum. Magrum.
Mr. Magrum, were you in the room earlier when I went through the penalties for perjury?
I don't think you ever did there, Judge, with all due respect. I don't think you did talk about perjury.
I did it with the very first witness, so I don't know if you're here or not, but I'll go through. I'm
I was-
required to go through them, so I'll
Okay.
just list them real quick. Perjury is a Class C felony punishable by a maximum fine of $10,000, a maximum 5 years imprisonment, or both. Do you understand what perjury is?
I do, but who's responsible for enforcing it here?
I swear you in. As far as any further prosecution of that, that would not be my office or the PSC.
So you administer the oath of office, but there's no enforcement, or who do you report it to, or if someone's lying, what happens then?
I believe it's recorded or reported to probably the county.
By who?
Again, I think this is outside the scope of what we're here to discuss, but
Well, Judge, with all due respect, I wasn't at the Morton County hearing, but I had a number of people contact me I am the senator for this district, and they asked me if someone commits perjury, who's responsible, because there was evidently, you ask everybody, I've been at almost every hearing, and your question is, do you understand what perjury is? And everybody says yes. And we all do. We think it's if you get up here and lie under oath, right?
correct, about a meeting.
Yeah, when you had a guy lie under oath, and the reason we know that he
Objection.
lied because the other guy
Objection, Your
came in and said that he lied.
Objection, Your Honor.
Well, I'm trying to understand because we have a
Objection,
legislative session
Your
coming
Honor.
up, Judge, in
Objection.
January, and we're gonna need to have to clarify this.
Your Honor, can I
because-
make my objection before this goes on any further?
Yes, please
This is
do.
just an effort to slander somebody. The Magrams filed a complaint that was completely inappropriate and for political reasons against somebody that spoke.
Judge, he's out of line there. He's out of line. He doesn't even know what he's
Okay,
talking
hang
about.
on. First off, we can't have people talking over each other. So,
Oh, he's making false accusations right there.
Mr. Magrum, if you please wait, I'm going to allow Mr. Dublinsky to make a record of his objection, and then I'll allow you to respond.
Your Honor, there was a complaint filed. It was thoroughly investigated by law enforcement who found that there was no factual basis for it, and the investigation was closed. So this is a non-issue. It's irrelevant to anything before this. It's being brought up purely to slander somebody else that they disagree with.
Point is, Judge, is we need to know if these people are telling the truth. This is showing how this
Your Honor,
company
can I get
has
a ruling
treated
for my
this.
objection?
Can I talk, Judge? This is showing how this company has treated the landowners from the very beginning and how they've lied to everyone. including us. I've been to the meetings. I was at the very first
Okay,
meeting.
Mr. Magrum, I haven't even swore you in yet, so like anything you say now can't be accepted as evidence because you haven't been sworn in. So I know you had questions about being sworn in, and what I can tell you is that I'm required by law to read to people advise people of the penalties for perjury and to swear them in before they testify, and that's required by law. But I can tell you myself as an administrative law judge in my office and the PSC, neither entity has authority to pursue actual charges for perjury. So I am going to sustain the objection, and I'm not here to answer further questions about that. If you have questions, you can talk to me after our hearing today, but I'm not going to do it on the record because it's not appropriate. So if you'd like to offer testimony in this case.
Don't the people deserve to know what's going on? I think
If you would
everybody
like to-
recognized that was a lie because everybody
Your
says
Honor,
they
I
understand
object to
what a
that
lie is.
characterization. There was an
So
investigation.
when they come in and then they
had no
lie, I
basis.
mean, people
Close
want
the
to know what,
investigation, and
people want to know.
Stop.
I wasn't cut off. He's interrupting me. But so, Judge,
Mr.
The
Magrum,
people had
we're
the
not going to
question.
talk about perjury anymore. If you have questions about it, I will answer them after the hearing, but I'm not going to do it on the record because that's not the purpose of this hearing. If you want to offer testimony, you need to be sworn in. So would you like to offer testimony?
yes,
Okay. And I assume you understand what perjury is.
I do.
And with being advised of the penalties for perjury, do you promise to tell the truth in this case
I
today?
will. Yes, I will.
And Mr. Magrum, I know you testified several times at our hearings last year, so I please ask you not to repeat testimony that's already been offered in this case. The commission is here to receive new testimony about the reroutes and any deficiencies in the order. So with that in mind, you can proceed.
Well, there's a lot of things that have come up in the last year. I mean, just things like people coming in and saying that, oh, well, if we don't do this pipeline, corn, the corn prices are going to go down or something to that effect. And the question I have as a businessman, if North Dakota has this huge advantage with geological storage, why would we be bringing in CO2 from other states to fill our pore spaces with? Seems to me that we have an advantage here to have a better price for our North Dakota corn. So what would be the reasoning to bring in Iowa, Illinois, Nebraska, South Dakota CO2? That's one of my questions that I have. It seems as if everyone that's promoting this project is going to benefit in some way. And so that brings up my other question. And so I was not able to listen to all the hearings this last week because number one, your technology wouldn't allow it. It kept cutting out. And I couldn't go back and watch the video. And so even the legislature, as soon as a hearing is over, it goes to automatic video. And so I don't understand why this commission doesn't have that availability. So I don't know, have they disclosed any of the other investors? I know last year when I was here, I brought up the fact that the Chinese are the biggest investor in this project. Now I was up at the nuclear triad in Minot when the Morton County hearing was going on, and they had a number of military individuals from all over the nation there. And the number one warning was, we are in a war with China. They said it over and over. That was the mantra all day. And yet the Chinese are the number one investor in this pipeline. I would think that would default them right off the bat. The way I understand it, they have a $300 million investment. Then you have the SK Group, South Korea, who has been known to take advantage of our country and our military. And then the third one is Tiger Infrastructure Partners, Saudi Arabia. There's 464 investors. The only other two that they've disclosed that I know of is Continental Resources and Summit Egg Group. So have they disclosed? And I suppose they can't ask any questions, but do we have any more information who the investors are? How do we know that this commission isn't investors? Why is it such a secret? But just the fact that these military individuals were warning us strongly, Watch for the Chinese. They're coming in. They're buying everything they can, whether it's businesses, farmland, infrastructure, windmills, pipelines, anything, oil wells. They're trying to get into every state. North Dakota is a target because of our energy. So that alone should disqualify this company from going any further. I was going to bring up the point when my son Aaron was up here, he had brought up that there is a public hearing that was in Emmons County. That is available on YouTube. Emmons County has that availability. You guys don't even provide that, which is very frustrating for me as a legislature, so I can keep up with what's going on. No, I don't mean to insult anybody, but I think that this next session, we need to look at trying to get some more transparency here. And there's been a big question about the number of the members on the board, if we should go to a 5-member commission. And that's something that we probably need to look at, as well as candidates taking money from industry that are running for this commission. And I was at a I met with a group of scientists last December, and they wanted me to bring back the message that 97% of scientists don't believe in man-made global warming, and the 3% that do only say they do because they need to get money for studies. They don't agree with it at all. And that these were retired scientists that have told me that there's such an attack on scientists for speaking out against this.
Objection, Your Honor.
Fascist that
I believe you're ruling with a different state legislator was that he would not be allowed to bring the testimony of third parties that are not here into the hearing. In that event, I think it's inappropriate to, again, give secondhand testimony on what scientists allegedly wanted this witness to bring to the hearing.
Mr. Magrum, if you could keep your comments to your own concerns, that would be helpful.
So I can't tell you about the Ed Schmidt, who's now deceased, God rest his soul. He was a World War II veteran, 97 years old. When I ran for the House of Representatives, he said, "Jeff, I'm going to vote for you, but I want you to realize there's a fascist movement in this country." And this was 8 years ago. And he said, "It's growing stronger and stronger." He was there when they freed the Italians from Mussolini. Mussolini was known as the guy that coined the term fascism, which is government and creating businesses to do their work. Now, Summit Carbon Solutions is the very definition of a fascist corporation, because they are created only for the government. There is no benefit to society. So he warned me. He said, I would love for you to oppose this fascist movement in America, because I see it coming here strong. And he was right. And here we are 8 years later, fighting a fascist movement that wants to take over our landowners' property. I mean, I'm blessed to be able to serve District 8 here. These are wonderful people you've seen today. They stand up for their rights, and they've chosen me to represent them, and I do that with honor. But they have been dishonored by this company, and I'm really frustrated by that. And here we are 3 years later, still hearing the same arguments. But there was a resolution, and I know this is a partisan board, right? There's normally three Republicans. Mr. Dawson, no offense, I don't know what party you belong to. But anyway, there was a resolution that was just recently passed. I mean, not only have I been to almost every hearing and heard nobody for this pipeline that isn't profiting. We had a Republican convention in March, and the vote for this resolution was 816 yes, 411 no, 2-1 opposed to carbon capture. And it reads, if you'll indulge me for a little bit here, the resolution reads, "Resolution opposing carbon capture and storage, supporting private property rights, and condemning use of eminent domain for CO2 pipelines. The North Dakota GOP Resolutions Committee, whereas corporations within the energy sector are capitalizing on the false premise of a looming climate apocalypse by introducing CCS projects into North Dakota, which would require the acquisition of land across various states, affecting numerous landowners and communities. An eminent domain is being considered to acquire the necessary land for the pipeline. And whereas the affected landowners and communities have expressed strong opposition to the use of eminent domain, arguing that it unjustly benefits a private entity at the expense of their property rights and local autonomy, demonstrating that there is a need for greater transparency, community involvement, and rigorous environmental and safety assessments in the planning and implementation of large-scale infrastructure projects. And whereas the North Dakota Republican Party supports the right of individual citizens to own and benefit from private real property ownership, and further affirms that the individual's right of ownership should be the primary purpose inherent in the use and value of their real property. Whereas the Fifth Amendment of the U.S. Constitution protects private property from public use without just compensation. Whereas there are substantial unanswered questions about the environmental benefits of these projects, their associated risks, and the long-term viability of CCS technology. Therefore, it be resolved that the North Dakota Republican Party condemns the use of eminent domain for carbon dioxide pipelines and calls for immediate halt to any such actions. Be it further resolved, the North Dakota Republican Party urges relevant governmental bodies to seek alternative solutions that do not infringe upon the property rights of individuals, that respect environmental and safety concerns, and that involve meaningful consultation and consent with the affected communities. And further, be it further resolved, the North Dakota Republican Party opposes the use of state funds to educate the public on the benefits of CCS that are contrary to the will and interests of private property owners, and opposes the fascism of mutually beneficial partnerships between government and private energy companies created under the pretext of climate change. And be it further resolved, the North Dakota Republican Party supports legislation that prevents the infringement of individual property rights without compensation, and provides legislative oversight of administrative rules that carry the force and effect of law. And so this was recently, I mean, you couldn't get a better poll. We had, like I said, it was 816 yes to 411 no. That's 2-1. And we had there's 47 districts in this state. We had people from 47 districts. If you did a poll in this state, you couldn't get a more accurate poll of faithful people that took their weekend off, spent their own money, went to Fargo to vote on this. And they endorsed Commissioner Chrisman, the same people that endorsed him to be our commissioner again for the next 6 years. Is it 6 or 4? I think it's 6. But anyway, those are the same people that are, and so it shows that the people are not in favor of this. This company is way out of line. They're coming in here and bullying with their Chinese money. The Chinese Communist Party is behind them. And that's why I do believe they're so arrogant. And when I was county commissioner, I was at the Capitol, and because I was invited up there, and Commissioner Crispin may have been a senator at that time, I don't remember, but they have these wetlands easements that are perpetual easements. And the farmers all over the state wanted the state of North Dakota to fight the federal government and try to nullify federal law on the wetlands easements. And they came to the Capitol, and there was a line down the hallway of farmers that wanted to get out of these easements. And that's what I see coming with this. If this gets approved, them same people are going to be coming, and might be the next generation. But these are 99 years easements. They're going to be coming into the state and saying, get us out of this. Grandpa or my dad or whoever signed us up for this. They took a one-time payment, and we are strapped with this miserable company. It might be the Chinese that own it totally by then. I don't know, because we're not stopping them. I know this next session there will be a movement to keep the Chinese out, but they've been whittling in anywhere they can. So anyway, I don't want to take any more time. And I just wanted to make them points that there's not the support in this state. If you can show me where it is, I'll be happy to listen, because I've listened, not as much as you, and I do respect I really do respect what you guys have put into this. And you put a lot of time, and I know it hasn't been easy because I've been sitting and I can get up and go to the restroom, whatever. And I do appreciate what you're doing. And I didn't mean to disrespect anybody here, but that perjury thing is something that needs to be looked at, because there's no point in having everybody take an oath if there's no, I mean, especially when somebody's lying and there's nothing happens. It's very frustrating to the public, and I hear it as a representative, and I'm happy to hear it. I'm not saying I don't, and I'm just bringing the message that, hey, if you guys know somebody comes in under oath and says something, another guy comes in the same day, the same hearing, under oath and says he's lying, I mean, something needs to be done about that. But anyway, I respectfully ask that you reject this citing application based on the many reasons I've given, and I'd stand for any questions or sit for any questions.
All right, thank you. Mr. Dublinsky, any questions?
No questions, Your Honor.
Mr. Pelham?
I don't, thank you.
Mr. Broughton?
No, Your Honor.
Mr. Jordy, any questions?
Yes. Sir, are you a sitting senator right now?
Yes, Mr. Jordy, I'm the senator for District 8, which is all of Emmons County, and it goes into Burleigh County. We have Lincoln is our largest community. We have Moffett, Minokan, and Wilton is up on the north end, which is in Burleigh, and part of it's in McLean County. So we actually have parts of 3 counties.
So assuming for argument's sake that Summit's pipeline will save the North Dakota economy, do you believe that enabling South Dakota, Minnesota, Nebraska, and Iowa ethanol plants to compete against North Dakota ethanol plants is a good thing for North Dakota?
No, Mr. Jordy, I think, I mean, I've been a self-employed businessman since I'm 19. If I find a competitive advantage, I take it. And so why would we as North Dakotans, if we're gonna, I think North Dakota would have been more acceptable to a carbon pipeline if it was just for North Dakota, but to bring in all this other carbon to fill our pore space when we only have 1 ethanol plant, they're saying, well, why would these corn growers even wanna bring in, we have this advantage right now, and you have Blue Flint, you have Red Trail right now, they're already injecting in the ground, so they have a competitive advantage. Why would they be working against those 2 plants right now? It doesn't make any sense to me. So now, okay, so they want to collect from Tharaldson. Well, why don't they run a little pipe over along the interstate or something? And if they need to go to Beulah and Hazen area and eventually use it for enhanced oil recovery, which is not it's not proven. I've sat through, I was on Energy and Natural Resources Committee, and the EERC put on 2 days of information for us. And they admit there's no conclusive evidence that carbon dioxide is beneficial or can be used in the Bakken formation. As a matter of fact, what they do know is natural gas works better. The 2 mixed together might work, but just the fact that they don't even know, and that shouldn't even be brought up. It shouldn't be brought up. So the corn part makes no sense why our corn growers would want to support this pipeline. It doesn't make any sense at all. When you have a competitive advantage as a business guy, I would never give that up. That's poor business.
Thank you, Senator. I don't have anything further.
Commissioner Chrisman?
Well, to say Senator Magrum is, I think, a longtime friend. You said at the end that you meant no disrespect. And if that's the case, throwing out the innuendo halfway through your testimony that perhaps the commissioners are investors in this was not exactly the right way to accomplish, not being offensive. But I'm going to rise above that. I do have one question for you on your testimony. And this may have been provided when you testified last fall. And if so, just tell me and I'll go back into my notes and everything and find it. But in your testimony today, you said that Chinese are the largest investors, followed by South Korea and Saudi Arabia, I believe. Do you have documentation of that we can put on the record?
Well, Chairman, this is the information that Summit Carbon Solutions has given us.
Okay, if it's
It's
on,
right on the
it's on
front
the
of it.
record.
I gave it to you guys. That should be on the evidence already. I gave it to you guys when we had the last year's hearing.
Okay,
Right on the front, Summit Carbon Solutions, LLC investor list. That was their information that we have.
my only point is that it's in our record, and I didn't remember if you had given it to us.
Yeah.
I wanted.
But we would like, the public wants to know who the investors are. I mean, you got a company that can potentially use eminent domain. I mean, don't you think it would be right to know who these people are that own it? I mean, we don't know if there's a governor part owner, is Bill Gates. I mean, nobody knows. So we have all this questioning and conspiracy, you might say. But how can we stop it if we don't show them facts?
My
So
point,
I would think that this commission would ask for it.
my point, Senator, if you listen, I'm trying to help your argument.
Okay.
What you say here, what you say around town is one thing, it being in our record is another. I wanted to verify that that was provided last time and that it's in our record as opposed to if we didn't. So that's all I wanted to know.
And Mr. Chairman, that's why I didn't introduce it, give it to you again, because you already have it. So I was just, my question is, has there been any information been given that would add to this out of the 464 investors, if we would know more than the 5? And maybe something's been submitted, I don't know, but I haven't been able to keep up with everything.
Commissioner Haugen-Hoffert?
I'll answer a question that was directed at us. I am not an investor in the Summit Carbon Pipeline. And if I was, I would have the responsibility to recuse myself from this hearing. And I have not perjured myself.
Mr. Dawson, any questions?
No questions.
All right. Thank you, Senator Magrum.
Thank you.
Is there anyone else that wants to provide public testimony? All right, seeing none, Mr. Jordy, I think you have one last witness to call.
I hope he's still there. Yes, I do. I would call Mitch Kurtzman if he's in the audience.
Yep, I believe he's here.
Great.
He's going to hand us out some papers too. Okay, thank you. All right, I'll have you start by stating your name for the record and spelling your last name.
Mitch Kurtzman, Kertzman.
And Mr. Kurtzman, were you in the, well, I suppose you were, I saw you there. You heard me go through the penalties for perjury. And do you understand what perjury is? And being advised of the potential penalties for perjury, do you promise to tell the truth in this case today?
Do.
All right, thank you. Go ahead, Mr. Jordy.
Thank you. And Mr. Kurtzman, before we get into the documents you have in front of you, I just want to try to ask some questions about them and then get them into evidence. So I'm first going to start, sir, with what we've marked as Exhibit 58, which is a April 23rd, 2024 letter that I put together along with Mr. Liable for you. And it attaches your letter to Mr. Beauchamps, the governor, and also attaches some maps. Do you recollect that?
Sure do.
Okay. And that's a letter we sent on April 23rd again, and then Summit responded. Their response is in the record, so I would offer landowner Exhibit 58.
And Mr. Jordy, did you email that out earlier today?
Yes. And
Okay.
Roseanne should have uploaded it to the docket by now, I would think.
All right, any objection, Mr. Dublinsky?
And no objection, Your Honor.
Mr. Pelham?
No.
All right, landowner 58 received.
And sir, that letter was your attempt to put out kind of a least worst option should this pipeline be approved, essentially, is that right?
That is correct.
All right, was there anything about that letter or its contents that you felt you should highlight for the PSC?
In that letter, we were told that Summit had tried 11 times to communicate with us, to start a dialogue with us. That box right there contains all 11 attempts, and all it is junk mail that they sent to me. I have never had a phone call from Summit. I've never talked to anybody from Summit, ever.
So then what I'd like to do, sir, is I think you're aware that on June 2nd, Summit proposed a possible reroute with the caveat that it may not work. And then I had forwarded that to you, and then you were able to take a look at it. Your modification to that is marked as Exhibit 53, and I would offer Exhibit 53.
Any objection to 53, Mr. Dubinsky?
No, Your Honor.
Mr. Pelham?
No.
All right, 53 is received.
Thank you. Okay, Mr. Kurtzman, can you explain that exhibit that you're holding there and what you want the commission to know about it?
Yeah, what Summit sent us Sunday PM was a red line indicating their line moved still on our property down along the south edge. This gives them the benefit of not having to go seek another easement from someone else. They still would require an easement from me, and the next door neighbor is unchanged. Kurtzman Farm Trust has absolutely no interest in having 99 years worth of obligations to pay for the problems if that pipe is broken. It's a liability. 99 years of liability for the 5 generations of my family. We have no interest in that. We want this pipeline off our land. That's what this document says.
And in that document, it looks like the red line proposed by Summit on the southern boundary of your property, you've simply moved that a couple hundred feet or so south, so it would be completely off your property, correct?
Correct. And this is just a lesser of two evils option here. I'm not trying to put it there. I'm trying to get it off our land. That's it.
And throughout the alleged 11 contacts or alleged attempts to work with you, has Summit ever explained why they couldn't move the pipeline off your land or given you any excuses?
No.
As you sit here today, are you aware of any reason that would make it impossible for Summit to accommodate your wish and simply move the pipeline off of your property?
No, it's they can desktop that line just as well as they did the first one.
And sir, you prepared some documents and handed those out to the commission. Can you lay some foundation and tell us what was in those documents, and then you can explain the importance of them?
Okay. In item number 1, you've probably heard enough of this, so I'm not going to repeat it. It's about what happens when you release a bunch of carbon dioxide onto the ground. It's a worst case scenario. You've heard it before. So I'm going to skip past 1. And at the end of that section, it's going to seem kind of piecemeal here before I get started. The end of section 1 goes like this. Consider this. SCS proposed project consists of approximately 1,900 miles. Some people are saying 2,000 miles. It's somewhere in that neighborhood. Assuming a laying length of 40 feet, which is the typical 40-foot long chunk of pipe you can haul on a truck. That's over 250,000 welded joints. Put together by the lowest bidder on an accelerated schedule. And then if they pick up the other company that bailed out of this, if they pick up their load, that will double it. It'll be a pair of 24s. So instead of a 250,000 foot well, it's 500,000. Put together in soil that freezes to 4+ feet. I'm way off script here. The ground here freezes to 4.5 feet often. We try to put utilities at 6 feet so they don't get frost heaved. If you put a 24-inch pipe with 4 feet of cover on it, the frost goes down to the bottom of the pipe in a cold winter. When frost freezes, it expands. When it melts, it contracts. Steel pipe has to be flexible enough to take that. When it's bedded perfectly, welded perfectly, it probably worked fine. But we're talking about we're putting pipe through various soils. With contractors that are rushed. Steel pipe that's being built by a factory that has certain materials to work with. What I'm trying to say here is that there will be imperfections in this assembly. You could count on it.
And sir, help the PSC understand, what's your educational background?
I'm a military veteran, retired civil engineer.
And sir, would you purchase land that had the Summit Carbon Solutions pipeline on it?
Would I?
Would you?
I would absolutely not.
And do you believe if Summit forced its pipeline upon your land, that would devalue your land?
Yes.
All right. Tell us more about the information in the packet or what you have there. And if you want to kind of run through it, if that's easier, go right ahead.
Okay. I want to skip number 2 as well, jumping down to number 3. Concerning the generational impact to our land, if this gets built on our land, for the next 99 years, if you realize that a generation is 20 years, that's 5 generations. 99 years is 5 generations. That's a lot of great grandkids that are going to have to deal with whatever we do here today. The land with a pipeline containing a very large amount of asphyxiating gas will never again be a desirable location to build a home. It will never again be a desirable location for any use other than non-animal ag. This fixes the highest use of the land. It becomes a 320-acre tax liability. 5 generations of my family will have to live with the possibility of a catastrophic event that ends the life of people, livestock, and wildlife in an area defined at the time by wind speed, wind direction, topology, volume of carbon dioxide released. You can't have a pre-made model ready to show how it's going to behave, because it will not match. What I'm saying here is that the pipeline running less than 2 miles north of Hazelton, North Dakota, on the upwind side, if that pipe bursts, and it's a fair amount of gas that gets out, you can say goodbye to Hazelton. It can happen. That's 400 what? 400 and some people? 400 and some people dead. The carbon dioxide cloud doesn't destroy property, doesn't hurt plants. When you go back in after it's cleared away, all you can find is the dead bodies. Everything else is fine. Five generations of my family will pay property taxes on acres that will never have value greater than cropland. 5 generations of my family will pay property taxes on land that has been taken from us by a group of private profiteers for their monetary gain. No gain for anybody else, but yes. 5 generations of my family will have to somehow be prepared to be sued by the harmed party if and when there is a break on our property. This item right here is our biggest concern. We do not want to be liable for someone else's project that we never wanted. The sixth generation of my family will be left with the responsibility of cleaning up the mess when the pipeline is abandoned. Okay, I'll get less mad now. Concerning cover depth, if you, given the size and weight of modern farm equipment, envision what happens when one of those giant pieces of equipment mires in a low spot, a slough draw, especially at this time of year, lots of rain, everything gets good and wet. A wind will cause the top of it to dry up a little bit so the operator doesn't see that it's wet and he's farming along. It's happened to me. I've done it. When you mire in a several ton piece of equipment, it will go down to steel and keep going. If you look at the size of that equipment nowadays, a pipe that's buried with 4 feet of cover over the pipe is going to be hit. A pipe that is perfectly bedded, perfectly welded, might survive, might not. At which point there's a rupture, and guess who gets to be responsible for it? Not Summit, us. The 4 of us owners don't have enough worth to take care of a lawsuit from something like that. Six feet of cover would be more appropriate under ag land. And I urge you that if you must approve this, that you stipulate 6 feet under ag land. All right, I'm going to close up here. In earlier times, when someone tried to take another's land or livestock for their own benefit, this was considered a hostile act. People usually died, most often by gunfire, sometimes by hanging, and with the law on the owner's side. This is not this time anymore. Currently, as it appears, the one wanting to do the taking simply needs really big investors, regardless of the country the investors are from. We understand that Summit will likely assume the load from another proposed carbon dioxide pipeline that has dropped out, the Navigator. This will more or less double the currently proposed flow, meaning another pipe running parallel to the proposed 24, most likely another 24. Or a single 36, maybe. Either way, this would be the largest high-pressure carbon dioxide pipeline on the planet. And I believe the first one in freezing soil. A cover depth of 48 inches is inadequate under ag ground. 6 feet of cover would be more appropriate to mitigate damage from farm equipment. We ask that the commission consider a stipulation to provide 6 feet of cover where the pipeline is under ag land. If the commission approves this route, if you must, what is to stop Summit from taking whatever they want using eminent domain? Until emergency response training and equipment is clearly defined and bonded, it would be incorrect to approve the route. Training and equipment provided by the pipeline operator with provisions to keep the training and equipment viable and funded for 99 years. This is vital as the likelihood of pipeline failure increases over time. The old pipeline will fail more than a new one. And if we hand $50,000 to each county for emergency response, you can't even buy a pickup for $50,000. To be able to make an attempt at a rescue, you didn't need to get in there with a vehicle that's not internal combustion. It has to be it's got to be electric. How many electric rescue vehicles do we have in the state of South Dakota, North Dakota? Probably none. So if the pipeline operator is offering $50,000 to each county, it's chicken feed. Try $500,000 in each county to get properly equipped to respond to that. Consider the utility of a carbon dioxide pipeline safety tax paid by the pipeline owner to the affected counties for the purpose of funding, training, and equipment for as long as the pipeline is in operation. My tirade is done. Thank you for listening.
Sir, has Summit at any time provided you with any type of dispersion modeling or risk analysis specific to North Dakota or your area, your farm?
No.
And do you believe that if the PSC were to approve this project, that this pipeline would have significant adverse negative effect on the welfare of the citizens of North Dakota and negative human impact?
Yes, negative impacts, yes.
Yeah. All right, I'd like to offer the packet that Mr. Kurtzman provided around officially as an evidentiary exhibit.
It doesn't have an exhibit number, Mr. Jordy. What would you like it labeled?
Exhibit 59, please. Landowner 59.
Any objection, Mr. Dublinsky?
Your Honor, I have no objection to the first 5 pages, which are Mr. Kurtzman's actual comments to the commission. Attached to that is a scientific article. A couple of objections there. One, I think last week we had a similar situation where one of Mr. Jordy's clients, and I apologize to Mr. Jordy if I've got that wrong, but had tried to bring in a report from a geologist in Iowa, and Your Honor properly denied that on the basis that that expert wasn't available to be cross-examined about their own work. Also, I think there is an ample amount of competing studies and testimony, including expert testimony, on the issue of CO2 concentration and impact. So we would have no objection to the first 5 pages, but we would object to the attachment of the article.
Mr. Pelham?
Yeah, we heard testimony as to the first 5 pages. I don't think we heard anything about the journal article. So I don't know if this witness is able to provide foundation to that or not, but.
I can speak to that, Your Honor.
Hang on a sec. So, Mr. Jordy, are you offering the first 5 pages or the article as well?
Well, the plan is to offer it all. If I need to lay more foundation, I can take the time to do that for the article.
Yeah, you're going to have to do that.
Okay. Sir, we established that you're a retired engineer, held a professional engineering license, and you have cause to perform research relative to your concern about this project and found a particular article that you've included here today. Can you tell us why you believe that's important and your understanding of that article?
Yeah, if you go to page 2 on the stuff that I wrote, paragraph 5, I talk about where it only takes 10% concentration of carbon dioxide to cause convulsions, coma, and death. That attachment is the article, the scientific article that talks about that 10%. I wasn't going to throw 10% in there without a reference. That's the reference for the 10%.
And was that the point of the article to back up your testimony there?
Yes.
All right. And did you read the article and review it, and did it make sense to you based on your professional background and training?
It did, and there's highlighted text that zooms in on the part that I wanted you to see. It's on, the pages aren't numbered. It's on 3rd page.
All right. Well, I would reoffer all of the pages, not just the first 5 pages.
That explanation, Mr. Dubinsky, any other objections you want to put on the record?
Same objection, Your Honor. I still don't see how this is materially different than the ruling that Your Honor made last week with regard to the geological scientific report from Iowa.
Mr. Pelham?
Your Honor, I think the article is the article. The witness testified as to his use of it as a reference point. So I don't have any objection. I'm not sure that the witness has any medical degree, but I think he's relying on it to state what he stated in his testimony, which isn't being objected to. So for purposes of the offer, I do not have an objection.
I'm going to note Summit's objection. My understanding that it's being included as the site for a comment he made in his written comments, and there was no objection to the written comments, so it's being received for that purpose. I would also note, I don't specifically remember the one I didn't allow in last week, but I think I allowed some similar items in at other hearings. So I will admit it. And again, the commissioners can decide what weight to attribute to that, if any.
So is that Exhibit 59?
That is Exhibit 59. All right, Mr. Jordy, additional questions?
No, not for this witness, but I have to make a motion at this time. And so at this time.
Can we finish questions for this witness and then your motion?
Sure. That would be just fine.
Okay. Mr. Dubinsky, any questions for Mr. Kurtzman?
And no questions, Your Honor.
Mr. Pelham?
I don't, thank you.
Mr. Shook?
Just real briefly, I just want to confirm, I think we had an earlier witness that spoke to the parcel of property. I want to be clear. So we're talking about 135 North, 76 West, Section 26, and you or you're part of ownership of the entire east half of that section. Is that
We're
correct?
speaking for the entire east half.
Okay, I just wanted to make sure you had listed E2, E2, W2, E2, which I'm assuming to mean the east half of the east half and the west half of the east half.
Yes.
Okay, thank you for that clarification. No further questions.
Mr. Broughton, any questions?
Just a quick question. You had talked about that cover depth of 6 feet, and you had indicated that you were proposing that on ag land. When you say ag land, do you mean just cropland, or do you mean crop and pasture land and hay land and everything?
I don't have any ranching experience. I
Okay.
can only speak for farming a crop, row crop.
Okay, thank you, sir.
So I was talking about row crop ground.
Okay, thank you for clarifying.
Commissioner Chrisman?
I'm curious about your 6-foot cover depth recommendation. Is that something that you just came up with and that it would be more and better than 4? Or I notice you have a civil engineering background. Is there any, like you presented this study from Belgium on your concerns about CO2. Do you have a study like that, or did you get something
There's no
along the
study
line
for
that causes a good argument for that is the correct number as opposed to just better?
Water utilities and sanitary sewer utilities are always buried 6 feet or deeper to keep them below the frost and below getting damaged. Storm sewer does not have to have 6 feet of cover. The reason I said 6 feet is it gets that pipe down below frost. They're going to have frost problems. So if they bury that pipe at 6 feet of cover, frost theoretically only goes down to the top of the pipe. The pipe itself is out of the frost. That's why 6 feet.
Thank you.
Commissioner Haugen-Hoffert?
I just have one comment. Thank you for your military service.
Mr. Dawson?
No questions, thank you.
Any redirect, Mr. Jordy?
No redirect, Your Honor. Thank you, sir.
All right, thank you, Mr. Kurtzman. All right, Mr. Jordy, you had a motion you wanted to make?
Yes, Your Honor. At this time, landowner interveners make a motion for mistrial, or maybe more appropriately, mishearing on the basis of being prevented access to the summit dispersion analysis, risk modeling methodology, the toxicology, all of those documents and information that we've had lots of testimony on, and anything else that may have been provided only to the Public Service Commission and the commissioners, that's a violation of our due process rights, and a mistrial is appropriate on that basis. Thank you.
I've never had a PSC hearing where that motion's been made before, so my suggestion is that Mr. Jordy puts his motion in writing. But Mr. Pelham, I'm interested to hear what your thoughts are.
Well, I don't think the motion should be granted. I think it should be denied. Procedurally, as to whether or not the rules of civil procedure and specifically Rule 50 would potentially apply to an administrative hearing is questionable, but to the extent that it would, I believe that a fair and impartial hearing has been presented. Mr. Jordy and his clients can certainly, file a motion and outline their legal arguments, but the primary basis for the motion that's being made at present and here today is based on a decision that was made in August of 2003, which is subject to a motion for reconsideration that the commission has not ruled on at present. And as an alternative to that motion for reconsideration, as I understand, as Mr. Jordy knows, who's joined in the motion, and also for the alternative request that has been made, is for if the commission grants reconsideration, that it be allowed to question additional witnesses. That motion has not been ruled on, so to the extent that procedurally it's not a proper time to be making this motion, as well as to whether or not it even can be made. But I appreciate what Mr. Jordy is doing. I do think the motion should be denied. Thank you.
I guess I have more of a practical consideration that I serve at the pleasure of the commission, and I don't know that this is a motion that I would consider, or be requested to address. So I think perhaps it's easier if it's submitted in writing and the commission can decide at what point in this process it wants to consider that motion.
Well, Your Honor, I need a ruling on it as the evidentiary portion of this is, there's no other hearings set. And so I would request a ruling on it so the record's preserved at the conclusion, which is today, of these scheduled hearings.
Are you moving under Rule 50?
I'm moving under Rule 50 and any other possible rule that fits this description. All of the above.
Well, Your Honor, on the commission's behalf, I think we stand in recess. I'd like to consult with our own legal counsel.
Take a short break and then, we're going to take a short break and consider or figure out how we're going to proceed. So we will take, we'll reconvene at 5 o'clock. All right, before we go any further, I'm just going to ask if there are other parties we have here today have any position on Mr. Jordy's motion, Mr. Dublinsky?
Thank you, Your Honor. Generally, we would join in with what Mr. Pelham said. I also agree with Your Honor that I think that there are vehicles for this. There is already the motion to reconsider. I understand Mr. Jordy's position of pushing for a ruling because of the conclusion of the taking of evidence. But I would note that part of the relief that is sought in the vehicle that is already in front of the commission does request, as part of the relief, the ability to reopen and have additional witnesses. So I don't think there's any prejudice by today's hearing concluding without a ruling. We think that, again, while this isn't necessarily a court per se, that tribunals do from time to time review material in camera. That is not an unknown thing, and it's certainly not an improper thing. And on all those bases, we think you can deny it outright today. If for any reason the commission is not inclined to do that, however, we would like an opportunity to respond in writing and would agree that the better practice would be to have Mr. Jordy file it in writing. That does seem a little redundant with the motion to reconsider already out there on the table, however.
All right, Mr. Broughton.
Thank you, Your Honor. I generally agree with what Mr. Pelham was saying earlier. But I would also point out that I think Mr. Jordy's concern may also be just with what a lot of trial attorneys are concerned with, which is a waiver of certain claims, rights, and arguments. And I understand that as well. What I would say, just to add to the discussion, is that there's specific standards for appeals as well in 283246. And one of those is that the rules or procedure of the agency have not afforded the appellant a fair hearing. And I do believe that this issue is one that, if not before, will be addressed on an appeal. And so the only other thing I would add to the discussion is that I think that this is a way that Mr. Jordy is procedurally getting that decision in front of the commission prior to a final decision. But unless it is going to ultimately change that final decision or the evidence coming in at these hearings, I don't know that ultimately it makes a difference when it's made.
All right, thank you. Commissioner Chrisman? Your microphone's not on.
First of all, Your Honor, thank you for a little break to consult with counsel a little bit and just think here from the commission's perspective. This is a procedure that has never happened in my 11 and a half years at the commission. But I guess when we get maybe highfalutin out-of-state attorneys, we learn new tricks at the end of hearings. I will say that we've had a full hearing, many days. And when the scheduled days didn't work out for Mr. Jordy, we even scheduled more days so that it could. So there's been a lot of opportunity. Evidence has been presented. There's been cross-examination, re-examination. The dispersion modeling was presented to the commission. It's subject to a protective order. So I'm going to move on behalf of the commission in response to Mr. Jordy's motion for a mishearing, if I think that was the term he used. So I move that motion be denied based on evidence having been presented and the prior orders of the commission, including the protective order.
Second.
So there's been a motion and a second. You want to do it? Okay. There's been a motion and a second. Further discussion? Hearing none, all those in favor signify by saying aye.
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 All those opposed? No opposed. Motion carries.
Mr. Pelham, We usually vote by roll call, so just that the record reflect, I believe it was.
We'll do a roll call vote then. Commissioner Chrisman,
Aye.
Commissioner Haugen-Hoffert,
Aye.
substitute decision maker Dawson. Aye. The ayes have it, and the motion is denied. Or the motion is carried, denying the motion to motion for a mishearing.
All right. That brings us to, well, actually, before that, I should just double check, Mr. Dubinsky or Mr. Glut, was there any rebuttal testimony that Summit wanted to provide?
No, Your Honor.
All right. Well, that brings us to the end of the testimony and the end of our hearing for today. Before we conclude, I'll just ask if there's any other matters we need to address, and I'll maybe start with you, Mr. Pelham.
The only thing I would say is I think the parties do need to submit post-hearing briefing. I want to say that in the past, anywhere from 20 to 30 days, and then a responsive briefing schedule would be similar in nature as to that. So I would leave it to the parties to determine what the deadlines would be for that, but I think that should be outlined today before the close of today.
Are you thinking 2 deadlines?
Simultaneous.
Simultaneous and then a reply?
That's my suggestion, but if the parties have alternative suggestions on how to do that, I'm fine with it. I just think that it should be determined today what it's going to be.
Sure. And I'll start with Mr. Glut.
Yes, Your Honor, we agree with Mr. Pelham's recommendations. We'd recommend 20 days simultaneous filing of post-hearing briefing and maybe a somewhat shorter time for reply briefs, maybe 15 days.
And what was your suggestion or recommendation?
20 today and 15.
Okay. Let's see, Mr. Broughton.
I can accommodate whatever is going to work for everyone else.
Okay, and Mr. Jordy?
Yeah, to be clear, that motion was for mistrial or mishearing, so I just want to be clear, it was for both of those things. 60 days, 60 days would probably be sufficient given the complexity of the record and the volume of the record and all the legal issues in play. And simultaneous, definitely.
All right, well, I've got a 20 and a 60, so we're gonna go somewhere in the middle. How about, let's see. How about July 8th for deadline for the first brief? And then the 22nd for rebuttal? All right, hearing no objection to that, those are the deadlines we will go with. Any other matters to address on behalf of the commission, Mr. Pelham?
With the, just to be clear, and this typically is a practice, proposed findings along with the post-hearing briefing would be requested as well by the commission.
Okay, so the first deadline, July 8th, we'll make that for closing arguments and then propose findings of fact, conclusions of law, and a proposed order.
Your Honor.
Sure.
Just, I guess I'm asking a question, but I want to maybe just alert to the parties to it, if nothing else, which is that Emmons County at least has a somewhat more limited interest in the proceeding than, for example, some of the others. So with respect to the proposed findings, I would plan to just submit proposed findings and conclusions on those issues and not on every issue.
I think that's acceptable. Mr. Glutter, Mr. Dubinsky, any other matters we need to address before we conclude?
Just a couple, Your Honor. Just want to follow up on yesterday and today. Mr. Bason's submitted written testimony yesterday that addressed numerous reroutes, received questions from the commission as to how would we know when these reroutes are going to be implemented. And we also heard some testimony today about some additional potential reroutes. And I just want to confirm and support what, or reaffirm what Mr. Bason's testified to yesterday, is that as if these routes are implemented and secured through easements, that the applicant will be updating the commission with respect to those, and that the applicant will continue to follow the route adjustment rules in the Siting Act accordingly. So that was issue number one. The second issue has to do with some clarification on some exhibits and some offering of additional exhibits. Your Honor, was last Tuesday, we received the direct written testimony of Jeff Olson. I don't recall if that was admitted into evidence.
I've got too many lists going on. Yes, I have it listed as SCSR 16.
Okay, thank you, Honor. And then the other items that someone would like to move to admit in response to requests from the commission. Someone filed a response to request for commission at docket number 562. The applicant supplemented that response at docket number 569. And then filed an amendment to that response at docket number 593. And the applicant would move to admit those into evidence as exhibits, I believe 21, 22, and 23 respectively.
Just be clear, that was Summit's submission to the commission for a request for information from the commission, correct?
That's correct, Your Honor.
All right, Mr. Jordy, any objection?
Is that information that was publicly filed? It was Summit's responses that were publicly filed to the commission, to the docket?
Correct. Correct. It was in response to the commission's request for information.
Yeah, as long as it was all publicly filed, no objections.
Mr. Pelham, any objection?
No.
All right, so 21, 22, and 23 are admitted.
With that, we have nothing further. Thank you, Your Honor.
All right, Mr. Jordy, any other matters you would like to discuss before we conclude?
I think we've covered it. Thank you.
Mr. Broughton, any additional items?
No, Your Honor.
All right, would the commissioners like to provide any closing remarks? Commissioner Chrisman?
None, Your Honor, other than to the public that is here. I thank you for your time and your patience and for the information. It's helpful. Thank you.
Commissioner Haugenhofer?
Wishing everyone a good evening and safe travels.
And Mr. Dawson?
I'd like to thank the public as well. Some of you I've seen so many times. You've come to almost every hearing, and that's quite commendable.
All right. Well, I'll just note for the record, it's 5:11 p.m. and that will conclude our hearing for today.